Hello, everyone, and welcome back to Warner, Norcross & Judd's The Right Side of the Law. My name is Madelaine Lane, and I'm a partner in the litigation practice group here at Warner Norcross, and I specialize in criminal defense. Today, I'm joined by my colleague, Liz von Eitzen.
Hi, I'm Elisabeth von Eitzen, and I am an attorney in our Kalamazoo office, and I specialize in bankruptcy law.
So, Liz, typically, people don't want to be calling either you or I, right? Because in that circumstance, they're either contemplating filing for a bankruptcy, or they're involved in a bankruptcy as a creditor, or they're involved in some sort of criminal case. But oftentimes, I find that there is some overlap between our two practices, and we wanted to discuss that today. So what is the advice that you would give somebody who is a debtor that's contemplating filing for bankruptcy?
So the first thing is you need to tell the truth, the whole truth and nothing but the truth. That whole adage in criminal law is also the same when it comes to bankruptcy. You get yourself into trouble in two circumstances: failure to disclose, or you lie on bankruptcy pleadings. You file your schedules, your statement of financial affairs, your statement of intentions, everything is under penalty of perjury. So if you lie on there, you have now committed a crime. Likewise, if you fail to disclose, you have committed a crime. And so, on these schedules, you have to put down every asset you own or that you have owned in the near distant past. So whether you transferred an asset 1 month, 6 months, or 2 years ago, you need to disclose that. There are many times during the bankruptcy case where you will be testifying under oath, whether it's at a 341 hearing, a 2004 exam, or some other hearing that's in front of the court. Again, you're testifying under oath. You must tell the truth. I can only help you if I know the information. There's a fine line between asset protection and bankruptcy fraud. The crime is never the fact that you transferred the asset. The crime is you failed to disclose that you transferred an asset. And as you know, there are consequences when you do get caught. And maybe you can describe what those are.
Absolutely. So if someone has engaged in bankruptcy fraud, so they've intentionally either devised a plan to hide information from the bankruptcy court, as you described, or actually went through with that plan, the federal penalty for that, if you're found guilty of bankruptcy fraud, is up to 5 years in prison and $250,000 fine. But of course, as you know, typically bankruptcy fraud isn't the only charge the federal prosecutor will bring. A lot of times they'll also bring charges for wire fraud or mail fraud, and that has a 20-year maximum possible penalty. So in recent years, we've seen this quite a lot. In 2014, I think a lot of people are probably aware of the reality stars, Teresa and Giuseppe Giudice in New Jersey.
Of course.
Were convicted of bankruptcy fraud and some tax crimes as well, and got 15 months and 41 months respectively in prison for that. And he, because he wasn't a US citizen, was actually deported back to his home country of Italy after he completed his sentence. And more recently, and closer to home, in 2018 here in Grand Rapids, a federal judge handed down a sentence for 45 months for an individual who had engaged in bankruptcy fraud, I think with the amount in the millions of dollars. So as with anything, it certainly depends on the facts and circumstances of the case, but it sounds like that's a very good reason to give you a call as soon as you're contemplating becoming involved in bankruptcy.
Exactly. We can only help you if you call us and you tell us.
Well, thank you very much, Liz, and thank you everyone for listening today. Please keep an eye out for the next edition of The Right Side of the Law vlog. And again, if you have any questions about the topics we discussed today, please feel free to call Liz or myself or your Warner, Norcross & Judd attorney. Thank you.
Thank you.